Hello, I'm Richard Wish, a Professor of Competition Law at King's College London, and I am the presenter of this ICN module on leniency programmes and leniency policy. In the course of what follows, you will also be hearing from officials from a number of competition authorities around the world, and you will also see some reenactments of hypothetical cartel meeting.
I don't think any of us can afford to play that game any longer. I think it's time we go back and take a look at our previous arrangement.
Could you be more precise?
We all raise our prices globally, and in conjunction with that, we stop approaching one another's clients and stick to our own territory.
Is it illegal?
Yes, you might have a serious problem here. What you have described as a cartel, which is against competition laws.
It is highly important for cartelists to be first through the door to cooperate with the Commission, since companies further in the queue can only receive reduction of their fines, no full immunity from fines. Experience has shown that granting full immunity only to the first one may indeed create a dynamic which destabilizes cartels and creates a race among cartelists to disclose their conduct to enforcers.
Under the Commission's 2006 leniency notice, companies that do not win the race for full immunity but still cooperate with the Commission's investigation may benefit from a reduction of fines that would otherwise be imposed on them.
The Bundeskartellamt initially only informs the applicant of his ranking and that he is in principle eligible for a reduction.
It is important that a relationship of trust be established between an immunity applicant and the competition authority.
Once the information is reported, it's crucial that the applicant has means to prove what he said.
Many agencies, including the ACCC, encourage people to approach the agency on a hypothetical basis. In this situation, people can contact the agency and inquire about whether, if a cartel existed, they might be able to apply for immunity in relation to that cartel.
In practical terms, delivering an oral statement requires that the applicant, usually represented by its legal counsel, comes to the Commission to dictate the statement and have it audio recorded. Such an audio recording is further transcribed and verified by the lawyer for its accuracy.
In the international cartel enforcement arena, a noteworthy difference among jurisdictions relates to whether individuals face personal legal exposure, and in particular imprisonment, for cartel conduct.
Well, obviously we talk to each other, we run into each other all the time at conferences and things. This is a small world. And yes, we talked a bit about prices.
Oh, but if that's true, you might wish to consider cooperating with the competition authority.
ECN members have realized quite early on that putting national leads together was an efficient way to detect cartel cases of European dimension. And the car glass case of 2008 is one of the most convincing examples.
As for international cartel cases, it is not rare that an enterprise concerned submit the immunity application to competition authorities in multiple jurisdictions at the same time.
So, we hope that this video has enabled you to understand better what a good leniency programme would look like. And remember, an effective leniency programme should mean fewer cartels and more competition.